Hello, everybody. Welcome to the OADC Ethics Seminar, The Lying Client, which unfortunately is once again a virtual affair thanks to our new normal. I'm Brian Scott. I'm the managing attorney for American Family Insurance here in Portland in its legal office, and I'm an OADC board member. I'm co-moderating today's webinar with John Eichelberg, who is staff counsel for farmers and who is also an OADC board member. I'm very pleased to introduce our other presenters today, our panelists, Marth Hodgkinson, Steve Houze, and Amber Bevacqua-Lynott. Martha has practiced law for 35 years in Oregon and is a partner in Hodgkinson Street Mepham, LLC. Her practice emphasis has been in civil litigation in construction, real estate, professional malpractice defense for design professionals, brokers, and attorneys, as well as representing public entities. In 2021, Martha transitioned her trial practice to a full-time neutral practice, and she now mediates disputes in construction, real estate, professional malpractice, commercial litigation, and complex BI cases. Martha was a past president of OADC in 2004 and has been a speaker and author in many risk management seminars and continuing education classes. Thanks, Martha. Portland criminal defense attorney Steve Houze has for over 40 years maintained an exclusively criminal defense practice in Oregon state and federal courts. His practice covers a wide spectrum of serious criminal matters ranging from death penalty defense, a major federal terrorism case, white collar fraud and environmental cases, drug cases, sex assault cases, and professional discipline matters. Steve is a graduate of Brown University and Vanderbilt Law School. After spending more than 3 years as a trial attorney in Portland's Metro Public Defender Office, he opened his private practice here in 1976. Throughout his career, Steve has represented thousands of individuals, among which have been some of the most noted cases in Oregon legal circles. Thanks, Steve. Amber Bevacqua-Lynott. Amber has more than 20 years of experience. She received her Juris Doctor from Pepperdine in 1996. Before that, she got her BA from the University of Redlands. She's licensed in California, Florida, and Oregon, although presently inactive in California and Florida. After a few years in private practice, Amber joined the Oregon State Bar's Disciplinary Counsel's Office in 2001 as an assistant disciplinary counsel. In that role, she was responsible for investigating complaints about unethical conduct on the part of attorneys and prosecuting charges where authorized to do so. Recently, Amber joined the Portland and San Diego offices of Buchalter, Ater, Wynne to assist in the development of the firm's newly formed professional responsibility practice group, which is designed to provide honest and pragmatic advice and guidance to professionals experiencing uncertainty about ethical issues and challenges to their license, both informally as well as in regulatory investigations and formal proceedings. Now, some housekeeping. I do want to thank all three of our panelists for being willing to appear via Zoom to present today and to field your questions. Before we start the bulk of our seminar, I wanted to quickly walk through some of our housekeeping items. First, your microphones and video are muted are muted for the webinar. So to ask a question, please enter it into the chat section, and then John or I will monitor the chat section and ask the questions of the presenters on your behalf. Please feel free to submit your questions at any time, and we'll try to answer as many of them as we can. Due to the limited time available, we may not get to all of them, but we'll try and get them all in. OADC is applying for CLE credits for this presentation. We're also recording the presentation, and we'll be making it available at a later date. We do plan to circulate the presentation materials, details on how to receive CLE credit, and our contact information via email after the webinar. With that, let's go ahead and start our presentation. John, Martha, Steve.
Thanks, Brian. Thanks to everybody who joined us today. As Brian told you, our topic today is the lying client, and more specifically, our ethical duties as lawyers when we encounter an untruthful client. We thought we'd start today by talking just generally about lying and human nature and why we lie. especially involving people who are involved in litigation. So Steve, why don't you start us out talking about that?
Thanks, John. Happy to be here. Welcome, everyone. As was indicated, I've been practicing for longer than anybody else here, and that perhaps is why you want me to go first so I don't nod off later on in the proceedings. But let's talk about lying. What is a lie? A lie is an intentional or deliberate deceitful statement or comment made by a person to have an effect upon the listener. It's different than an honest mistake or a misunderstanding of fact or an innocent misrepresentation of something. It's something that's quite distinct. Well, why do people lie? It's essentially pretty simple. People lie because they fear the consequence of the truth, telling the truth, or they lie because they want to gain unfair advantage in a proceeding or some circumstance involving other people. What's interesting about this topic to me is when you cast it broadly enough, the entire foundation of our legal system, particularly as it relates to court matters, is that we believe and we have established rules that are premised upon the belief that people will lie if given an opportunity. For example, why do we administer oaths? Tell the truth, nothing but the truth, so help you God. Putting the fear of God in someone so they will tell the truth. Rules of evidence that are quite elaborate, jury instructions, a witness false in part may be distrusted in other parts of their testimony. Cross-examination, a powerful, powerful tool to use designed to ferret out inconsistencies and indeed lies when they occur when someone testifies. Well, those are all fine, but honestly, and the reason we're talking here today is the bulwark that prevents a distortion of the truth, the admission of lies, corrupting the system, is really dependent upon the lawyers in the system. Lawyers present the evidence. We call witnesses. We elicit testimony. That's why we're talking about the obligations of lawyers and how lawyers can determine whether someone is lying or not, hopefully, and what steps you must take in the face of that. Now, as a criminal practitioner, I have a certain perspective on this that is different in some respects from those of you who practice civil law. But as a general proposition, lying occurs in all spheres here. And most people aren't very good liars. They're pretty poor at it. Some lies are very easily detected. Others are not so easily detected. Lies oftentimes sound good at first blush, but when you penetrate it a little bit logically, it doesn't hold together. So what we want to do is give you what we hope are going to be some interesting insights into this phenomenon of lying and what lawyers should and should not do. But more broadly speaking, I think this is about how lawyers practice law with an awareness that people don't always tell the truth and what you can and should do to avoid the worst kinds of examples and the calamities that can come when people do lie in legal proceedings. I think you muted, John.
Sorry. Amber, Martha, anything you'd like to add in before we move on?
Well, good afternoon, everybody, and thank you for coming. From my perspective as a civil lawyer practicing as long as I have, you don't go into business being a defense lawyer in particular, thinking your clients are liars. That's not, you wouldn't be having much of a business or a practice if that's the way you approach things. However, many times, I'm sure that I'm not the only one, once you get involved in a case or a matter with a client, you sometimes find that there's a tendency for that client to say things, do things that make you wonder what is really behind the story of the client. And we want to like our clients. I think everybody would agree that we get a client, even if we have an assignment from an insurance company, we want to like our clients. We want to believe them. We want to win for them. We want to do whatever we can to get to a successful resolution of the case. So many times, myself included, I think Steve used this phrase earlier. I don't know if he'd use it just now, but in our preparation for this, in civil practice, it's very hard to see whether something is a bull-faced lie on one end of the spectrum, or simply, as this was suggested, a sincere but false belief of what the person is saying. And that is the difficulty in a civil practice, because a lie, an outright lie that you can call on the client or anybody that you're talking to, the opposing counsel, opposing party, is a lie. But if you encounter something that's not really very clear, it's in a gray area. Is it a lie? Is it an embellishment? Is it just this person's truth? Everybody's speaking their truth these days, and it doesn't always add up to what the truth is. So over the whole course of a case, if you're working with a person whose story changes, who has information that is inconsistent with objective established information, it's going to put you on notice that there could be a problem. And oftentimes it is just simply a matter of consulting with the client or advising them. You can't really say things that you aren't able to prove, or that we can't prove through the progress of the case. You can't make stuff up, and you can't lie. So hopefully through this process, you'll be a little bit enlightened in terms of differentiating what is really a sincere but false belief in a set of facts versus an outright lie. And I have had probably 3 cases in my career where a client has lied to me, and I have tried to fix it, call the client on it, and in one case had to resign because a lie is a lie. And as Amber is going to explain as we go forward, we are walking through a minefield of ethical rules, issues that impact everybody. It impacts the court, it impacts opposing parties, it impacts witnesses when your client turns out to be a liar.
So let me ask you, this whole seminar and these rules that we're talking about today deal with a lie told by a client. How do you determine that a client truly has lied? And how certain do you need to be before you take the action that is required by the ethical rules?
Question for me?
Sure, Amber, go ahead.
Well, the court has said that you have to be pretty certain. There are cases in which I know there's a case out of Colorado, I believe it's Colorado or something similar, where a lawyer's immigration client said she would do absolutely anything she had to do, including lie on the stand, to avoid being deported. So the lawyer took that information that she was going to lie or thought she would lie and disclosed it, and was found to have violated RPC 1.6 by disclosing her client's information. So you have to be very certain that a lie is in the course of happening, and we're going to talk about that throughout today. But you have to be certain it's in the course of happening, and you have to do and it's the rules depend very much on if you think it might happen, if it's in the process of happening, or if it's already happened. The rules treat it very differently, but there is no magic, I don't know how to put it, a magic card that says this is a lie and this is not a lie. You have to try to look at these things objectively. Sometimes we ask lawyers to look at it as if they were a disinterested third-party lawyer. Would they see this as a lie, not with your lenses on? Sometimes that's helpful in being able to tell whether or not, or determine whether or not that's actually a lie. But I wish there was some magic answer as to when you can tell and when you can't.
Okay, and another question about lies. Is there a distinction about the seriousness of the lie, the magnitude of the lie? Maybe with little white lies at the one end of the spectrum and lies that are really fundamental to the case at the other end of the spectrum. Is the size of the lie relevant in this analysis?
Well, I think the better, I don't know if better, but the analysis is actually more on materiality than it is the size. So if it's not something that's material, then it may not be an issue, although it should send all kinds of red flags of what the client is capable of. And so put you on high alert if they're lying from the outset, if you can tell that they're saying things that just don't comport with the facts. But most of the rules you'll see today talk about materiality.
Okay, all right. And because most of us have never met our clients before, some of us have returning clients or clients who come back numerous times for representation, but most of us have never met our clients before. So I'm assuming then that we learn about clients' lies as a case develops, correct?
Yes, from the criminal case perspective, we ordinarily will have early on receipt of discovery, which will contain, for example, interviews the police may have conducted with witnesses and with a client. We'll then have a meeting with the client, and the client will relate to us all the circumstances they know about the case, including the circumstances of an interview if that occurred. And it is not uncommon when a case file comes to you, if it is not a videotaped or audio recorded interview with your client, it's a police officer's summary of a conversation. And it may vary dramatically in some important respects from the client's recollection of what was said in that interview. So I've always proceeded from the perspective that a police report is someone else's version of what took place. And I want to know firsthand from the client. I then will analyze that information as well as I can using common sense, life experience, and other facts that we believe to be objective and immutable in the case to make my own initial determination of whether I'm dealing with someone who is being candid with me across the board and in specific with respect to any statements they would make, their account of the events, for example. And you start from there. But more fundamentally, I think it is to be preceded by framing your encounter with your client, your engagement as a lawyer representing a client, and explaining your role as a lawyer and what your expectations are. That I will be your zealous advocate. I will fight for you. I will do everything in my power within the rules of ethics to be your advocate. And I expect you, for your part, to be brutally honest with me. And whatever you tell me, no matter how unflattering you may think it is for you in your case, it's not going to make me want to not represent you. It's not going to be a value judgment I make on you. I need to know the facts, whatever they are, the good ones and the bad ones. And then we determine what course we will follow. But if you don't tell me the truth, if you lie to me, if you try to mislead me thinking that's going to help you, that's a fool's errand, because it will be uncovered undoubtedly. And the consequences of lying to me and trying to have me unwittingly present some false version of events is going to be catastrophic in all likelihood. The consequences are worse. And I think if you frame it that way and you gain control and the confidence of your client, you can largely avoid many of the things we're talking about here today. It is the rare person who is the inveterate big lie teller who doesn't have a conscience, who's going to look you in the eye and say, I won the election. And everybody knows it. There are those people, but fortunately there aren't too many of them. Most people want to rely upon the information and the advice they receive from their lawyer because they're worried, they're scared, they don't know how to navigate this terrain, and that's why they're seeking your professional guidance. So we can't be potted palms. We've got to take charge right away, instill confidence, and lay down the yard markers when we represent people so that they know where they dare not stray. And I think that kind of preventive approach carries you so very long in this exercise of being a lawyer representing people.
Okay.
I think that's absolutely true. And in the civil context, it's a little bit different. There's not literally life or death hanging in the balance very often, based on whether a person is telling you the truth or not. But the first thing that I do, and my radar's up, because I know we don't know our clients until we get a case assignment. We meet them for the most part, and then you kind of get a read on the person. If I'm sensing from this person communicating to me, and just by way of background, in my practice, I represented a lot of professionals whose income was predicated on communication, talking, writing things, all sorts of communication, which of course can trap you up later on. But what I say to everybody in the first encounter is, you have to tell me the truth. I don't care. I don't care if it's bad. I don't care if you've done something bad. We can't change that. There's no motion to change the facts. We have to deal with it. And you have to tell me every single thing that I need to know to protect you and help you in this case. And Amber will talk about this, but at that point forward, and if the person does confide in you and tells you perhaps some things that occurred in the past that are inconsistent with what they're telling you now, that's a private and privileged communication. There's nothing you can do with that information about what has occurred in the past. It's what's going to happen in the future that needs to be sort of reckoned with, and where your radar needs to go up. Because if you have a client who you believe plays fast and loose with the truth, and you know that from prior incidences, then you should be prepared that that pattern could continue. And of course, a person is not going to sit in your office in the first initial meeting and say, or on Zoom and say, well, yes, I lied in this publication before, but I have to keep it going. I'm going to have to do this again. I'm going to have to perpetuate this statement going forward. And this gets back to the materiality part of it. This is an integral part of the case and must be dealt with. Then you're going to have the heart-to-heart talk with the client and say, we can't take that position going forward. I want to help you and I will help you, but here's why. And you can't perpetuate a lie, an untruth going forward. You think that it's not, and I've had a client say to me, well, the other side's going to lie. So I need to be prepared, and I need to say what needs to be said. And the answer is, let the other side lie. I would tell that person the same thing I'm going to tell you. If you perpetuate a lie, it's going to come back to you one way or the other, as Steve just pointed out. So there are clients, and I'm sure we've all had them, and it seems to be, I don't know, in the last 5 or 10 years, people have an increasing ease in telling lies, and it's very unfortunate. And it's very hard to detect a person who's a very good liar. And by calling your client a liar doesn't mean you don't like them. You're not going to help them. It just means you've got a problem that you have to deal with if this person doesn't take your advice and continues to lie down the road. So the initial meeting where you really kind of lay out the rules is really important.
Amber, before we move on, there are some rules that are invoked when you have to deal with a client who has lied. And I know you've prepared a PowerPoint presentation. Brian, could you put that PowerPoint up and we could just briefly go through the rules that we're going to be talking about today so people could look at them in their rule book if they want to while we keep going? Brian, are you still trying to pull those up?
Well, I'll
Yes,
just jump
I
in.
am.
I'll just jump in a little bit and start talking about that, because I know
Sure.
that people are generally familiar with the rules that apply to this. Everyone's familiar with that you can't make a misrepresentation, a knowing misrepresentation. Under RPC 8.4, A3, you can't engage in misrepresentation involving dishonesty, fraud, or deceit, or any of those things. And so that comes into play. But the first part of that rule says you can't violate the rules, knowingly assist or induce another to violate the rules. And so I think that's where whether or not your client has engaged in a lie comes into play. So that's where you may get into trouble under that particular rule. So if you want to go back up then to the beginning, RPC 1.6, it's the first slide. It says that there's only a few, so it shouldn't be too hard. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent or it's authorized by Section B. And there's a lot of exceptions that are listed there, but for our purposes, B1, to disclose the intention of a lawyer's client to commit a crime, and it's necessary to prevent the crime, to prevent reasonably certain death or substantial bodily harm, to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. Basically, charges against the lawyer in some fashion. And then to comply with other law, court order, or as permitted by the RPCs. So there's not a lot of circumstances under which you're allowed to disclose a client information if you know a client has lied, particularly if you know they've lied in the past. Now, the reason that really comes into play is because of RPC 3.3. In Oregon, RPC 3.3 provides, 2 slides down, perfect, that a lawyer shall not knowingly, there you go. A lawyer shall not make a false statement of law or fact to a tribunal or fail to correct the false statement of material fact. Now that's, the lawyer can't do it. So that could be you perpetuating the lie that your client is told if you know it's a lie. And that also implicates Section 3, which says that you can't offer evidence that you know to be false. And you then must take remedial measures if you know of something that's false and it's given to the court. The reason that I said that 1.6 comes into play is because if you see under RPC 3.3A3, it says that a lawyer shall take reasonable remedial measures, including, if permitted, disclosure to the tribunal. And then if you go down to Section B, and it says that if a lawyer knows that a client intends to lie, he or she shall take all remedial measures, including, if permitted, disclosure to the tribunal. But then C specifically says that the duties in A and B, no event require disclosure of information protected by 1.6. So you can see how there isn't a whole lot of information unless somebody is going to die or you're in the process of committing a fraud or helping your client commit a fraud on the court. There's not a whole lot of information you can share and disclose in order to remediate. So you're gonna have to find other ways to remediate the evidence. This is critically important because Oregon's rule is not the model rule. So if you practice in other states, you need to be aware of this. Oregon's rule is, the model rule says that instead of if permitted, it says if necessary. And it doesn't have the red language that's indicated there. It doesn't have that any information protected by RPC 1.6. Instead, it says, notwithstanding that it would otherwise be protected by RPC 1.6. So you need to take a look at the state that you're in if you happen to have multiple licenses. I know Washington State is the same as Oregon. It does protect that information. California and Idaho are not. They are strict model rule states, as is Colorado. So you need to be aware of whether or not the state that you're representing that client in says you've got to hold it inviolate because you're subject to 1.6 or says you have to disclose it notwithstanding 1.6. So I think that's really important. Sometimes the thing you have to do in remediating it, if your client's not going to fix it, is withdraw. That's what our court has said. And so then that implicates Rule 1.16. which talks about what you should do when you have to withdraw. And that's under that, if you're going to violate the rules of professional conduct, which you would, if you continue to represent the client, 3.3 or 8.48A1, then you need to withdraw. That's a reason to mandatory withdraw. And it's also other good cause. But you have to comply with the rules of the court. So you have to give notice. So then what comes into play, RPC 1.6 comes back to be an issue, because what do you tell the court when you withdraw? So
Okay. And we'll talk
We'll
about
talk
that
about
in
that in a
more
minute,
detail
yeah.
as we go through. Right. Okay. So that's a general overview of the rules that are implicated here involving a lying client.
exactly.
Let's go through the litigation or prosecution process here and talk about when lies occur and how we deal with them.
Okay.
Steve already dealt with this a little bit, but let's talk about lies that our client has told before we became their lawyer. And a couple of examples. Police show up at a crime scene and interview someone who's willing to talk. Probably shouldn't, Steve, right? But they do talk to the police.
Sure.
The police show up at car accidents. They show up at all sorts of situations, and people talk. We meet the client. We don't yet have the police report. We subsequently obtain the police report. And what our client told us in our initial meeting is very different from what the police report that they said at the scene of the accident. At this point, we're a counselor. We need to call our client up or have them come back in and talk to them about a lie they may have told immediately after an incident happened because they panicked or thought they could get out of it. But what advice do we give to a client who may have told a lie to someone else that is recorded somewhere, and they've now told us the truth or a different version? What advice do we give them?
Well, as I approach these things, John, it depends upon the format in which the alleged lie exists. Is it a recorded statement or is it a police report, someone's version of a conversation? But whatever it is, that statement itself may have been obtained in a fashion that is unlawful. It may have been violative of a statutory or constitutional right of the client, in which case you would be moving to suppress or exclude that statement. That's one approach to it. And if you succeed in doing so, that no longer exists. It cannot be used. And under Oregon law, that prior excluded statement cannot be used for impeachment purposes if the client then gives the truthful version later at trial. If, on the other hand, the statement is not subject to suppression, it's out there, it lives, and it's going to be used for impeachment purposes, that is one of the pieces you confront in a criminal case in advising a client whether they should exercise their constitutional right to testify or not, knowing it would come in. In some instances, the client's testimony is indispensable to presenting a complete and successful defense. In most instances, however, we choose not to put our clients on the witness stand in criminal cases for very good reasons. It may be apparent to others, but frankly, it's because we live and die by our power of cross-examination in criminal cases. We take apart the prosecution case. They have the burden of proof. We have no burden of proof. And it's a skillful cross-examiner can do significant damage to the prosecution case. Likewise, if your client testifies, even if they think they're a great witness, they're going to be cross-examined by a skillful cross-examiner and the prosecutor. And you could have built the best defense taking their case apart that can be built, and then everything shifts to the focus on your client when they testify. And if they are found to be unbelievable, either because they gave a prior inconsistent version that they try to explain away, or the manner in which they do it is not convincing, game over. So we often don't really confront this problem because it is the rare instance in which a client actually does testify in a trial in their own defense. But sometimes you have to do it. And if that is the case, depending upon the nature of the false statement they gave, gee, I only had 2 beers, officer, versus I was in Detroit when that bank was robbed in Portland, you may have to confront the question of, does the client have to eat the prior lie? And then try to explain the reason they gave that false statement. Hopefully in a convincing fashion that people will understand as a function of human nature. And the client, by being contrite in the present tribunal, will be seen as a person that they can identify with and believe that, who wouldn't lie, who wouldn't exaggerate or minimize or whatever the case is when confronted in a panicked situation. But that does not go to the issue of whether they are believable or not in a general sense. It's just an instance of not telling the complete truth.
Okay, so in a criminal case, the defendant lies at the scene of the accident, scene of the shooting, scene of the crime. You meet with the client, he or she admits to you that was a lie. They're not going to take the witness stand. They're not going to testify at their trial. There is no ethical obligation to act upon that admitted lie they told before, correct?
There is not.
Okay, Amber, you agree?
Yes.
Okay, Martha?
So here's a little bit of a different twist. In a civil case, opposing counsel can compel your client to testify in a deposition. Whole different set of facts and rules. So here's a hypothetical that kind of is parallel to Steve's, but in the civil context, your new client comes in, tells you a story of an incident. It can be an accident. It can be intentional infliction of emotional distress. It can be something where the person's conduct and statement is a very big part of the case. And your client tells you their version of events, and you proceed, you file an answer, perhaps with affirmative defenses, maybe a counterclaim. You respond to requests for admission, and then something lands in your lap. It could be a prior statement in written form. It could be an audio tape. It could be a videotape. It could be something that's objectively tangible that 100% negates what your client has told you. And remember, you've already acted on that information because you've made a filing with the court. That's now front and center in the court file, not only through the answer, but through the request for admission responses. So then what do? Talk to the client. And this is a very, very tough situation. It's gut-wrenching if you encounter this for the first time, because your ethical duties are one thing, your reputation as a lawyer is on the line, and then what do you do with your client? How do you fix this? So in the circumstance that this happened to me one time, you can imagine that we had a discussion about where we find ourselves with this information. And the client is always going to, human nature, say, well, that doesn't tell the whole story, this recording that you have, or this written communication that you have. It's not my truth is really what happened, and I can explain. And that's where you need to have the discussion about explaining. You can explain, but that's going to make it worse. You're going to dig yourself into a bigger hole. It's not going to end well. And oh, by the way, I can't perpetuate that if I believe that there is evidence to the contrary that is basically you can't challenge. So this starts the process of repair. If your client is willing to do this, if your client is willing to listen to you and say, oh, okay, I see what you mean. This is bad. I should have said something that somebody might disagree with my version of events. And then you start the very painful but necessary repair process. You undo it. You amend your answer in a very subtle way. You amend your requests or your responses to the request for admissions, because everyone knows if your client proceeds to trial or even in summary judgment and is found to be untruthful and has denied a request for admission, and that turns out to be the wrong answer, then there are consequences. And if a court finds out that there is something before the court that expresses a lie, and that lie is uncovered or exposed, there are consequences. So you must, at this stage, before any depositions, before anything except for the pleadings we've just talked about, you've got to figure out how to unwind this. And you have to tell your client, this must happen, or I can't represent you, because my ethical duties to the court, to opposing counsel, to as an officer of the court, do not permit me to perpetuate this when I believe that it will be, and I'm not saying that you are a liar with intent to deceive. I'm saying that you put yourself in a position where a fact finder could think that you are lying and continuing to lie. So that in this step of the process, that's kind of what has to happen. And you may be in a position to say to yourself, I can't trust this person. I'm not comfortable going forward, engaging with opposing counsel, filing briefs, having depositions taken. and have this emerge as an ongoing intentional misrepresentation or a lie, and you may have to withdraw. And Amber may
Okay.
disagree with me on that, but
And Amber, maybe you could comment on that, pick up from where Martha left off. You filed something with the court representing your client. You discover a lie that your filings are based upon. You go to your client and you say, we need to correct this. And they refuse.
Mm.
Tell us about whether or not you as the lawyer can even try to take any corrective action at that point, or if you need to withdraw and leave that to the new attorney that's going to pick up the representation.
Yeah, the poor next attorney, right? Yeah, you're right. If you have to try to take remedial measures, if your client refuses to allow you to take those remedial measures, then you must withdraw.
And you cannot take any further action on their behalf in the case, correct?
Not that would perpetuate the lie.
Okay,
You still have to be mindful that under 116, you've got to protect their interests.
sure.
So 116D requires you take all reasonable steps to protect their interests. And so you may have to request a continuance or do something on their behalf that ensures that they're not prejudiced by the fact that you have to withdraw at that time.
So realistically, like Martha said, if what you have filed with the court contains an affirmative defense that is based upon a lie that your client has told,
Mhm.
continuing in the representation, the next logical step in the case is a deposition where your client's going to be asked about that affirmative defense. Can you continue on with that representation if the next step is appearing at a deposition sitting beside this liar who's going to tell the lie?
Yeah, if they're not going to, in that deposition, correct the affirmative defense and testify truthfully, they're going to testify in accordance with what you know to be a lie. You cannot permit that to go on. You can't permit to put them under oath and allow them to testify falsely. The court, the case law that's out there has said the depositions, while it doesn't specifically say depositions in the 3.3 rule, they are under oath, intended for testimonial purposes. So it's just like lying to a court, and you can't let that happen.
John, let me jump in for a second
Yeah, go ahead, Steve.
on something Martha and Amber have said, and that is the interrelationship that often exists between criminal and civil cases. It is not uncommon that there are parallel proceedings, criminal and civil, based on the same alleged conduct. And that implicates one's rights against self-incrimination, a powerful tool to use to prevent, for example, being deposed in a civil case that is, intended to ferret out information, true or not, from your client vis-a-vis the use of it in the civil proceeding. We often try to coordinate very closely with civil counsel to make sure that answers given in response to a civil complaint, deposition requests, demands for production or admission are oftentimes held in abatement, move for an abatement of the case so you don't confront that dilemma. Sometimes it's a civil case that's in the wings. It hasn't been filed yet, but you can anticipate reasonably that this tort case is going to happen. It's a fraud or it's a personal assault, something that's going to lead to litigation, and you have to be mindful of that. And many times we seek to enlist civil counsel representation of a client in anticipation of that. It gets dicey. The criminal case tends to drive the train in those circumstances, as one might imagine. Money is one thing, reputational damage is one thing, but being incarcerated as a result of a conviction of a serious criminal offense takes precedence. So we try to coordinate these things, and I have found, and no offense to civil practitioners, many civil practitioners are not mindful as they should be of the potential criminal implications of a standalone civil case before criminal charges are ever contemplated. Answers given in a deposition that are demonstrably false, for example, can lead to a potential prosecution for the false statement or for a perjury if it's serious enough. And likewise, answers given in connection with civil litigation can uncover the facts that could lead to a prosecutor being referred a case for a potential prosecution that otherwise would not happen. So it's complicated. But again, you just need to step back when you begin the case and say, okay, what are we dealing with? Is it civil and criminal? Is it potentially a civil, potentially a criminal? How do we proceed carefully? And that will guide us in terms of what we say to clients about what they can or should not say going forward in any proceeding.
So,
And Steve,
Don, I have a couple of examples.
Yeah, go
to
ahead,
follow
Martha.
up. Oh, with what Steve was saying, twice in my career that I can recall, I have had a client who is simultaneously either being prosecuted for a crime related to the same set of facts that I'm defending the client on, or the prosecutor's trying to decide whether or not to bring charges. And in both cases, fortunately, I was aware of these criminal proceedings or the intent to potentially file. So I was able to work with my client, in one case, try and get that client a criminal defense lawyer to help me go forward. And this is the one where the charges had not been brought yet. And on the other case, I was asked to meet with the prosecutor in defending my client. And I did as a courtesy, but I could do nothing. I just listened. It helped me understand the gravity of the charges against my client and what I had to do. Then working with their civil or their criminal lawyer, what I had to do going forward. And basically, I tried to get the civil case abated or stayed pending the criminal prosecution, but the court didn't allow it. So in deposition, there were no answers given. Everything was answered on the basis of invoking a person's right not to be witness against each other, Fifth Amendment right. So that can happen. And it's very, very confusing. It's very, it's difficult. It's frustrating because you're not going to be able to move through the civil case. But because the burden of proof is lower than a criminal proceeding, there is a lot of bad evidence that can come out of a deposition, as Steve was saying. So this is one time in my career where I instructed my client, you have to take the Fifth Amendment every single question other than, what's your name?
Okay, so moving along, we are representing our client. Discovery has taken place. In a civil case, we go to a deposition, and during the deposition, our client shocks us by telling an obvious lie. And again, we're assuming we can tell they're lying, that we know it's a lie, and that it's a material lie. What, as the person's attorney, a lie has just been spoken on the record under oath. What do we do? What do we have to do at that point? What is the mechanic of dealing with that lie in the middle of a deposition?
Martha, what have you done?
Okay, what so you have to stop the deposition. You have to stop it temporarily first, and then, as we'll talk about, permanently, but you have to stop it to talk to your client. And you need to advise your client that we're at a crossroads here. You need to go back and correct your testimony, which will be detrimental to you, obviously, but it's a lie. We can't continue the deposition with that lie out there for a variety of reasons. So the deposition, if you're not going to correct it, we're going to have to stop the deposition. And the other tool that we haven't talked about is, and I've done this before, not in the middle of a deposition, but after something like this, is to call the PLF, the bar hotline, the ethics hotline, to get some quick advice. Just to know if you're doing the right thing. For example, if you're a young lawyer and this never happened to you before, and it'll happen to us all for the first time, and this happens, if you can't find a partner or somebody, your firm's ethics person that you bounce things against, just call the bar and say, here's what's happening in real time, or here's what did happen. And you'll get some advice that isn't specific to the case, but it will be with someone like Amber, who knows the ethical rules, who will guide you in the right direction. It's very, very, it's a very valuable tool. But going back to the deposition, you've got to stop if the client won't correct it. The other lawyer is going to be very angry, seek sanctions, seek costs, terminating the deposition, but you have no choice because you can't allow the client to continue testifying untruthfully, knowing this is going to end up in the courtroom. It violates the ethical rules, and it can't happen. So at that point, when you terminate the deposition, then you've got to determine if you can continue to represent the client. And for the most part, this is a situation where you're probably going to have to withdraw. If the facts are as egregious as John was describing, blatant lie, everybody knows it, not going to correct it, just sitting there like, too bad, I'm not going to, that's what I'm going to say, then I think that you have to withdraw.
Amber, you agree?
I agree. You have to,
Okay.
if they're not going to withdraw, you've got to get out.
Okay. Let me take it one step further. I don't know that your answer would change at all, but looking back on the olden days when we used to actually get together for depositions in person, and we used to walk out of the room and walk to our cars with our client, your male client just testified that he was alone in the car when he caused an accident. And walking out to the car after the deposition, he says, "Hey, I lied. I had my girlfriend with me. I didn't want my wife to know that she was in the car with me. So all of a sudden now there's a lie. And I think it's a material lie because now there's an eyewitness who you've become aware of. What do you do at that point? The deposition's over, concluded. How do you deal with it?"
Well, you go back to your office, you sit down with the client and explain to them what has occurred is a very, very serious problem and it can't continue. And again, this is speaking for me, from my interpretation of the ethical rules and just what's the right thing to do for the client, because you're still representing them. I mean, you have at this point almost conflicting duty, but you have to sort through it. And that's kind of one of the reasons that this should be a helpful CLE. You got to think about these things. So you tell the client that's a problem. We have really only one choice, which is to fix it. And fixing it is going to be, it's going to blow the thing open from your perspective. I'm sorry about your wife not wanting to know about your girlfriend. You don't want her to know, but this can't continue. You can't continue this course going forward. And I can't allow it as my client. I want to protect you, and we'll try and figure out a way to unwind this or to soften the eventual blow of correction. But we can't go forward with your testimony like that when it's false. So same situation, but you have a chance to try and fix it. And this could be another situation that Steve was describing where maybe there was a prosecution looming out there for a bad driving accident that's a crime. Maybe it's already been initiated, maybe it's in the works, but that complicates it further. So you really have to, at this point, talk to your client. And if there is a potential criminal or an actual criminal proceeding, you're going to have to defer to the defense lawyer a little bit to how we fix this mess. But I could see a scenario where you just end up withdrawing without saying a word to anybody about anything, and no one will know. And it's up to the client to get it when he gets his new lawyer, civil lawyer, to make sure that he's communicating with his new lawyer and with his criminal lawyer in a way that both lawyers can help him. But if you're a civil lawyer and your client says, I'm not going to fix it because I don't want my wife to find out, then I think you have to withdraw. And I think you've got to communicate to the criminal lawyer that you're withdrawing. And I think this is okay to do, I'm going to defer to Amber, but I think you're going to have to communicate with the criminal lawyer, because you're both representing the client, about the gravity of the situation.
John, let me ask a question, if I may, of Amber in this context, and that is, what duty does the lawyer have to help the client who has lied in that circumstance obtain independent advice from you? Because you're in a conflict situation now. Your duty of candor to the court, your duty of candor to your opposite party, your zealous advocacy on the other side. What do you do when you confront the client with the fact that you may need to withdraw, or you're recommending to the client they take some corrective action? Do you have a corollary duty to advise the client to obtain independent from you legal advice as to what course they should or can follow?
Probably. And I will say probably because if you believe that your ethical duties are inhibiting your ability to continue to represent the client in any way, that implicates the only rule we didn't look at that I have a slide for, which is 1.7. And 1.7 says that if you, it's a conflict of interest if you have a personal interest that is contrary to your client that's going to affect your representation, then you have to get informed consent from your client, which includes the duty to instruct your client to seek independent counsel. So, and that's, in that instance, it's 1.7A2. Significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client or by a personal interest of a lawyer. So if you believe that and rightfully so, you do believe you can't continue to represent this client if they're not going to fix the lie, that's absolutely true. So yes, in those instances, you could say that 1.7 was also implicated. So you probably should go ahead and recommend to the client that they seek advice from another lawyer.
So in my hypothetical, you're leaving the deposition, the client divulges to you the presence of the girlfriend. He doesn't want his wife to find out. You advise the client that he needs to fix it. He refuses. Steve just brought up the issue of candor to the opposing counsel. Once the client refuses, you have a duty to withdraw. So the lie stands, the lie in the deposition stands, and you ethically, you cannot put the opposing counsel on notice of the issue.
Right.
Okay.
That was my take on it, or is my take on it. You can't divulge, it's still a client confidence.
Okay. All right. Dan Tennell had a good question in the chat, and before we move on, we are in a world where we tend to specialize in the kind of work we do. I know that I'm handling cases right now, drunk driving cases, where the plaintiff does bring a claim very quickly, either while a criminal prosecution of my client is going on, or even before charges are brought. But ethically, how do we find out if there might be charges brought? We don't want to go to the DA and say, hey, are you going to prosecute my client? They might not have even had it on the radar, but you bringing it up might cause them to take action. The interplay between civil and criminal, if charges have not yet been brought, and our client testifying in a lawsuit that's brought very quickly, discovery moves quickly, depositions are scheduled quickly. How do we know that the statute of limitations might mean that charges are not brought for quite some time? How do we deal with that?
Well, John, the answer to that is simple on one level, complicated on another. The simple answer is you should assume that criminal liability is a real thing in that circumstance. You don't have to have an actual pending criminal case in order to invoke your right against self-incrimination. It's the potential. And the Fifth Amendment rule, as it has been construed by Oregon and other courts, is such a broad prophylactic protection, and rightfully so, that if there is any potential, that's all it is, potential, that you could incriminate yourself, or something you say could lead to an inference, and upon an inference that you might be subjected to criminal prosecution, you can rightfully invoke. In these cases, you have to make the tough decision, strategic decision. What is more important to you, client? Is it trying to defend successfully against a civil action, knowing a criminal case is likely in the wings or maybe in the wings? Or is it to say, I'm not, do whatever you're going to do to me civilly. First, we'll seek to abate it if we can. And sometime during that period of a year's abatement, in all likelihood, we'll know whether there's going to be a criminal case brought or not. But we've got a principled basis upon which we can approach a court and seek abatement or remedy and avoid that very dilemma we're talking about. Do you give any testimony in a deposition or in a civil proceeding in any fashion, request for admission, etc., while you're worried about the specter of a criminal case coming. You just need to assume the worst case scenario and act from that perspective, in my view.
And I think, Martha, you commented on the fact that you tried to do that one time, and did I hear you correctly that making the argument that charges might be brought weren't enough for a civil judge to abate a case?
Correct, that the judge denied my motion to abate, but that's when I, knowing how much I don't know about criminal law, I got a referral for my client to a criminal lawyer. So the criminal lawyer could advise the client and help me navigate through what I couldn't change. So I think that's really a good thing to remember. If you're a civil lawyer and something like this comes up, call Steve or someone like Steve and ask if your client can retain a criminal lawyer to help navigate this, because civil lawyers, this doesn't confront us very often. And the Fifth Amendment, thankfully, is very broad, but I would feel more comfortable having an expert in criminal law advising my client before I take steps going forward.
Okay. So let's move on in the litigation then. Again, assuming we're talking about a civil case, you end up in a courtroom at trial, or you end up in a conference room at an arbitration, and the same situation rears its ugly head. You're sitting there, your client's testifying, and you know that he or she has just told a material lie. What are the mechanics of how we have to deal with that ethically right there in that moment?
Steve, you want to go first and I can comment?
Sure. Well, this presumes there is no existing criminal case for which you would have rightfully invoked your rights against self-incrimination. So if it is just the specter of a criminal case pending, first advice the criminal lawyer would have given to the civil attorney is, don't permit this to go forward. Invoke the Fifth Amendment. And under the Oregon Evidence Code and the rules that have interpreted it, there is no adverse inference that can be used or made for the genuine good faith invocation of the Fifth Amendment. It otherwise would, more heavily weight the invocation of a constitutional right than is permissible. So there's no downside to asserting the Fifth Amendment in that context, as it would relate to future problems you may face. But the ship has already sailed in that scenario, John. You're already in a trial, and you've lost abatement, or you have not moved for an abatement of the case. And that's kind of the worst case scenario. And if you are in that circumstance and the client has given that false statement against counsel's advice by testifying, whatever, you're in the mandatory withdrawal circumstance. I think if you're facing that, you can't let it go on. You can't.
What happens to you, Steve, though, when you're in a criminal trial and your client who had prepared beautifully and you want him to take the stand or her to take the stand? What happens when that happens to you?
Well, fortunately, it's never happened to me.
Good. Okay, good.
But
knock on wood. Knock on wood.
Yeah. You did. Not because I'm a genius. It's because I've been lucky, I suppose. But you take all those preventive steps we're talking about. But in the unlikely event the client goes off the reservation, so to speak, and does this terrible thing, you've got to stop the proceedings. You've got to confer with the client. There is an obligation, and it's not a pleasant one, but there's an obligation to try to correct the record, have the client recant that statement, explain it in a way that is consistent with the truth. And if the client is unwilling to do it, you have reached the untenable position in the worst of circumstances in which you cannot ethically continue with that representation. And then you get to this often very ugly circumstance of seeking to withdraw. It's a mistrial kind of a circumstance in a trial. And it's a mistrial necessitated by conduct of the person whose lawyer is then seeking the mistrial, which is going to be disfavored by the judge, going to be opposed by your prosecutor. But you need to make that record. You cannot allow it to simply go unattended to and say, for example, I'll leave that testimony stand. I will then argue the case for the client as if that was truthful, factual testimony, because you would be perpetuating the fraud that's just been perpetrated upon the court. You can't ethically do that. You're in the worst of circumstances, and seeking to withdraw at that point, if you cannot get the mistrial, which is unlikely, is your only remedy. And it's not
So
a
Steve, let's talk about the nuts and bolts of actually being in the courtroom and that happening. I would
So-
assume immediately after your client is told to lie, you're going to take a breath, casually shuffle through some papers, not look alarmed by your client's lie. And you're going to look up at the judge and say, I'm sorry, Your Honor, I think I have a matter for the court. Could we take a small recess?
First thing you do is say you need a recess
Okay,
before you say you have a matter for the court.
okay,
You need a break. You then
Okay.
retire to a confidential setting in which you can confront your client with what has just happened.
and Mr. Houze, we just took a bathroom break. We're not going to take a break right now.
Your Honor, I need a break. I'm sorry. Need to do this. Not prepared to go forward at the moment.
Okay,
You do what you need to do. You're going to get a break. You're going to get a break
okay,
after that's happened. The difficulty with these things, John, are this is a spun out of control circumstance that despite everything you have tried to do, have learned to do, has failed, and the client has done the unthinkable, the thing you did not plan for. If you're in that circumstance, you take a break. You're going to need perhaps a substantial break in the proceedings, in which you will need to consult with ethics counsel. You can't just blindly push ahead here. This has got to be very thoughtfully done because your client's liberty is at stake. Your duty of zealous advocacy is now in direct conflict with these very important ethical considerations of the conduct of a lawyer. You simply can't let this steam ahead. You can't let the judge steamroll you into this moving ahead without the opportunity to do what you need to do. It may be that you need to recess the trial for the day and take advantage of the kinds of resources that are out there with the bar and with private ethics counsel to guide you. You may need to be represented by ethics counsel in the trial proceeding as it relates to what would be a closed proceeding in which you make some representations to the court without necessarily spilling the beans as to, the client just lied under oath, but that you have an untenable, unreconcilable conflict of interest that regrettably necessitates your withdrawal, so-called quiet versus noisy withdrawal from representation.
and
These are nightmare
So-
scenarios, but you got to do it.
So there is, to my recollection, this has happened in trials, not to me, but with others over the years, where that sort of conflict has arisen in the middle of a trial. The lawyer has asked the court to be able to withdraw based on a conflict of interest and the other ethical considerations, and the court has said no. And this is a civil case, not a criminal case. No, you're not going to waste the court's resources. You're going to proceed. That is my ruling. So honestly, Amber, what does a lawyer do under those circumstances? Because I think you have to proceed, but then what do you do?
And Amber, in your comments, maybe comment on how much we can say to the court, because we are going to get questions.
Yes, you're going to get questions. And in the circumstance that you talked about, Martha, the bar, the Supreme Court has said that the lawyer can't be put in a position where they have to decide which evil is greater. And so they said in the instance where you are required by the court to continue, you will continue. So if you're not allowed to withdraw, you're not going to be disciplined because you failed to withdraw, at least as the case law stands right now.
What do you do about the lie, the big lie?
The lie, you can't rely on it. And Steve kind of brought up a good point because in 3.3, there's actually a provision at the end of, I think it's section 3, that you're not allowed to perpetuate testimony, and you may refuse to offer testimony that you know is false, except a defendant in criminal proceeding. So you may know all along that your defendant, he or she wants to testify on their own behalf, and what they're going to say is false. In those circumstances, you still have to let them continue. You still have to offer that testimony because as Steve was talking about, it's their fundamental rights. So then once you've committed, once you've allowed that testimony, you still can't rely on it in any way. So you're in the same position you would be if you're in the position that Martha was talking about, which is the court's not going to let you out in the criminal proceeding. You're not going to get out of that case either. So you can't rely on it. You can't use it in closing. You can't reference it again. You have to pretend like it didn't happen and you're not going to refer to it. That's how I see is about the only way you can't perpetuate it in some fashion. So that would be my recommendation as to that. If you can withdraw at that point, you need to say as little as possible, because you still have obligations under 116 and 1.6 not to give up more than your client allows you to, and also not to prejudice your client's interests under 116. So you need to start out by saying very little. I have a conflict because I feel like my continuing would violate the rules of professional conduct. I have a conflict with my client. I need to get out. The court knows. The court knows. They know what that means. In the instance where they're going to require additional explanation, you ask that that be made in camera. And you go back there and you say a little bit more. And to the extent that the judge requires you to divulge more information, then you're doing it subject to the court's instruction. That's what's going to cover you. But you don't want to say more than you have to, because that is where I've seen people get into trouble, is by saying way too much in their withdrawals and prejudicing their client's interests. So you got to be careful about that.
Well, and in real life, we're in a courtroom. We have stood up to say, Your Honor, I need a break. You've got 12 jurors looking at you. You would hope the judge would click in and figure out what's going on, but they don't always. And there's the awkwardness of trying to convince the judge you need the break without having to say why.
Yeah.
Because then you've got 12 jurors wondering what the heck's going on at your table in the courtroom. What's going on?
It's clear that something was just said is significant. Now you're putting a big spotlight on it.
Exactly. Exactly. So Steve, Martha, a judge says, no, we're not going to take a break. You plow ahead.
No, at that point, you say, I have a matter for the court.
Okay.
Which causes a recess in the proceedings.
Okay.
You have a matter for the court. It can't be spoken about in the presence of the jury, which is consistent with your obligation to not prejudice your client in any way. And indeed, in some circumstances, I think you might legitimately say, I need to be heard in camera. That is to say, without counsel on the other side present to make a record, at which point you make the bare bones record of the ethical conflict without disclosing the substance of it. Just, you cannot ethically proceed. And this course must be preceded by you have an opportunity to meet first with your client and explore the important dimensions of what has happened and the possible consequences of not taking the proper course of action. So, you're bailing out of the sinking ship at this point, but you have to do this in a way that is methodical, that is consistent with your obligation to the client, as well as to the court and to your ethical standards you must abide by. And you just have to insist on these things. I mean, that's where you as a lawyer just have to take charge as the captain of the ship of a very bad situation. But you've got to insist the court give you that audience, give you that opportunity. And I don't think there's a judge who's going to say, I don't want to hear from you, to hell with you, or, call your next witness or make your closing argument. You have that opportunity. You need to make that record. If it's all going to hell in a handcart, you've got to have made that record, if for no other reason, to protect yourself ethically, that you've taken every reasonable step to try to correct this situation and to do the right thing, quote unquote, from an ethical perspective as a lawyer. Having done so, if your client goes down in flames, is unwilling to correct the testimony, the court won't let you withdraw, and the client is convicted and decides to pursue a post-conviction relief action or bring a civil action against you for failing to perform your duties, effectively, et cetera, you're bulletproof if you do that, if you do those things. You as the lawyer have done all that can be expected of you. But I think in the real world of how things happen, if the client surprises you and does the unthinkable in the middle of the trial, you call a halt to it and you seek an audience with the court out of the presence of the jury, and you say as little as can be required of you to demonstrate that you have a conflict of interest that is irreconcilable. And you move for a mistrial, even if you're not going to get it. You do all those things to protect the client and ultimately, frankly, protect yourself from being accused of not having comported yourself according to the ethics rules.
Okay.
So John,
And-
you mentioned, and part of your question was directed to arbitration.
Yes.
And this is just kind of an observation. I've been doing a lot of arbitrations recently, and most of them are contractual, they're not court annexed. And there was an arbitration that I had in which one of the parties was testifying, and that party testified on a topic that I was familiar with because I'd read all their pre-hearing briefs, and all the, arbitration is different. You get a much better look at the world that you're going to be deciding. And it was clear to me, at least, that this witness was lying. The other side knew it, and his lawyer knew it. So there was a break. And when that party came back, there was a request to revisit his testimony, which of course was allowed. And it was walked back, corrected. And arbitration is an interesting way to obtain evidence because it's much looser. The rules of evidence are relaxed. And this was done, this lawyer did a great job of masterfully redirecting the evidence through his client, who fixed it. And he wasn't trustworthy, of course, after that, but he fixed it in a way that didn't require a mistrial. It didn't require an ethical blow up, but it was fixed. And I think in arbitration, you have that opportunity, and a good lawyer will see what's happening, stop, and fix it if possible. So it's just I think every circumstance is different, and you have to really be able to think on your feet, which is hard in this kind of situation.
But the actual mechanics are no different if it's trial versus arbitration.
That's
And-
true. And
and-
you still
and the
you
ethical
can't lie
duty
under
is no
oath.
different.
You can't lie under oath, but you're not in it with a jury, so that you don't. The fixing of the problem isn't potentially as catastrophic as
Sure.
if you were testifying in front of a jury.
Sure, sure. And then if we withdraw, those of us who are hired to represent clients by insurance companies, if we need to withdraw, we would have that same obligation to our client to not divulge to the insurer that our client lied, and that's why we need to be allowed to withdraw from the case, correct?
Yes,
Okay,
I think so. I mean,
we
based on the
simply-
tripartite relationship in Oregon, where your primary client is your client, not the insurance company. I think you have a duty always to avoid any commentary to the insurer that would basically deprive your client of coverage or any way, impact that client adversely.
okay. Now, Amber, one of the rules, and I think it's 3.3, talks about our duty continues to the conclusion of the case. Talk to us about what that means as far as dealing with a lie that we become aware of late in the case. Maybe during jury deliberations.
That was going to be my example. You're walking out, instead of out of the deposition, you're walking out of the trial, and your client tells you that they've lied, that their testimony was all a lie, and look at, we won. Isn't that great? There's still time for appeal. There's still time for post, if it's in a divorce proceeding, there's post, decree stuff that comes up. It would continue throughout all of that. And so again, you'd have the same obligation to try to get them to correct it, but to ultimately not prejudice them in some way if you didn't have to by not relying on it, but not prejudicing them if you don't have to. And if you're at the end of the representation and there's really nothing else for you to do other than wait out the period, then you may not have to withdraw at that point. But if there's anything else for you to do, then you'd have the same situation you did if it happened earlier in the proceedings.
I don't know that this happens very often, but it could. How does a lawyer correct a lie when a jury's deliberating? What is the mechanic of doing that? You bring the matter to the court? How do you deal with it?
Steve, I think that's a good one for you.
Sure. Well, desperate people do desperate things, as they say. In a circumstance such as that, the fact finder has the case, the evidence has been closed, the arguments have been made. So the record that has been submitted, if you will, to the fact finder would have to be reopened. So it would require a disclosure that, first of all, to the court and opposing counsel, that your client wishes to correct testimony. The court would have to agree to permit that. First of all, if the court, you've made the request, if the court refused to permit that to take place, you've done probably at least the minimum of what you're required to do in terms of bringing the false testimony to light, the implication that it's false testimony to light. You've sought a remedy. It's then up to the court to grant that remedy. The question gets dicier in terms of the court saying, no, I'm sorry, the record is complete. We're not going to reopen this matter. Tough luck, your client doesn't get to give a better version, in effect, of what he testified to under oath. And that might well be the position that the prosecutor would take in that case. That, you know, they've got the case. I think we're going to win it. We're not going to let your guy get a second bite at the apple here now that you've had a chance to think about it and you want to give it a modified version. But you've got to make some disclosure, I think, to the court that something has happened and that a remedy is appropriate. Beyond that, making that motion and seeing what the court will say, I don't know that you can say anything else.
Okay. But we do have an ethical duty at that point to try to correct it.
Correct.
All right.
So in a civil trial, taking that one step further, if your client admits to you that his testimony or her testimony was false, after the jury has been sent to deliberate, and that client refuses to allow you to take remedial action, that I think is a very difficult situation. It would be a horrible situation to be in, but I think, as Steve indicated, I think something has to be done. I mean, you have the knowledge that a person has told a lie that a jury is basing its decisions on. So, I mean, my best guess, if the client wouldn't agree to fixing the testimony, is you have to go back to the court and have a matter for the court and at least try and get a mistrial. I mean, that you can't say anything about it. But what bothers me about that is that then you are not advocating for your client or protecting your client for an after the fact lie. So, you know, what do we do here, Amber?
There's a perfect answer. I just don't have it. You know, you have to do the best you can to, and you guys are bringing up this concept, and I think that John wanted us to talk on it a little bit, that there's a zealous representation, but if you guys have noticed, the zealous representation rule doesn't exist under the RPCs anymore. There's no phrase called zealous representation in the RPCs. And so yes, you do have duties to your clients, and you have duties of confidentiality to your clients. But the model rules and Oregon, which Oregon is more or less adopted, and most jurisdictions have adopted some version of them, are moving towards the importance of the court being fully informed. And so we all have to be very mindful of that they're saying that the court having all the facts is starting to push up against the obligation that we have to maintain our client confidences and secrets. And in many states, it doesn't exist anymore, and you have to disclose. So Oregon has still got that remnant of, we still value so much that attorney-client relationship, that's gonna trump at this point, that's gonna overcome our other obligation for the court to know everything, but I don't know that that's gonna stay that way forever. So just be mindful of that.
So your client divulges to you that he or she has told a lie. You talk to them and say, I have an ethical duty to do something about that. And they say, no, you don't. I'm not going to let you do anything. You're my attorney. You can't hurt me. Don't do anything. That's where we pick up the phone and call the bar and the ethics hotline, right?
Or me, or call me.
Or call Amber.
Absolutely. And John, we're hypothesizing these kinds of circumstances necessarily, but I think the importance of seeking ethics counsel, private ethics counsel's guidance on this should not go unnoticed. It's vital. And, ethics lawyers have a very important role in these proceedings. You as the lawyer who is saddled with this seemingly insoluble problem need representation. You need a lawyer who can say to the court on your behalf. I mean, I had a case come up in federal court a number of years ago where we came into possession investigating a case of evidence of a crime, physical evidence of a very serious crime. What in the world do you do when something like that happens? Well, we hired Peter Jarvis to help us in that case. And it was very complicated, involving 2 federal judges. And we ultimately got a solution that was satisfactory to the court and to the prosecutors, as well as protecting our client. But it was not simple. And a lot of these problems seem to defy ready explanation. And a lot of lawyers have never tread on this ground before. So ethics lawyers exist for a reason. We should use them.
Steve, before we move on, I'm sorry, we'll get back to you, Martha. Before we move on, Joel Peterson is still in attendance here, and he asked a question. Steve, can you speak to written notices to the prosecution providing advance notice of invocation of Fifth Amendment rights?
Right. This can happen in circumstances in which, for example, a federal investigation is ongoing. You have not received a target notice that your client is the target of the prosecution. And they want to call your client, or they want your client to produce documents. And you can, in certain circumstances, document production can implicate the Fifth Amendment. Your communications with your opposite number on that, of simply saying, I intend to advise my client to assert his rights against self-incrimination, absolutely happens all the time. You need to do that. Sometimes prosecutors will simply accept your representation of that fact. Others, and it's unusual, but in other instances, they want your client to actually come to the grand jury and invoke in person. You cannot be in the grand jury with them when that happens, but you give them a written statement of their rights against self-incrimination to put into the record. And that's what you do. It happens.
And Martha or Amber, applying that to the civil realm, if there is a civil lawsuit going on where you have a fairly good idea that there may be a future criminal prosecution, would you advise giving written notice to the plaintiff attorney that if your client is called for a deposition, he or she will invoke the Fifth, basically saying, don't bother?
I've seen that done. And I think as a practical matter, I trying to analyze it from an ethical standpoint, I don't think that would violate the client confidence rule, because we often respond to discovery requests in writing and say things that are coming down the road. So I believe it would be acceptable to advise opposing counsel that if you notice the deposition of my client, he won't be giving you substantive answers. He'll be taking the Fifth Amendment. And I think probably as a practical matter, that would be a courtesy that would help to move things in the right direction versus having your client show up knowing that he or she's not going to answer any questions. That might result in a motion for sanctions, for costs for the deposition. There's all kinds of reactions that would be could be avoided by if you make that call. But to be honest, I'm not sure if that violates the ethical rules. I don't think it does.
I don't think it does either. I think that you're right in terms of all the other practical consequences. You're not, and your client, especially if that's what your client's going to do, if you're concerned about that, just ask him if it's okay, you share that.
Good point.
Martha, you shared with us a real life situation. Do any of you, including Martha, do you have other situations that you can share with us? Since not all of us have dealt with this issue, hopefully we won't have to, but issues where you've dealt with a lying client and had to deal with either opposing counsel or the court on that issue?
Well, let me jump in here, John. You would think that criminal cases are the circumstances because the stakes are so high where people lie more often. I don't know if that's true. It probably happens as often in divorce cases and civil litigation of all various types as it does in criminal cases. But in a criminal case, the consequences for someone lying can be far more severe, as in a prosecution for false swearing or a perjury prosecution. The knock-on effect of a person who is intent upon giving false evidence and you're trying to talk them out of it ahead of time, in terms of if you are insistent upon doing that, not only will I not be your lawyer, but if you go to lawyer number two and you don't tell that lawyer number two that this is going to be false testimony, but that's your plan, you are probably going to lose, and the consequence will not be lost upon the judge when it comes time for sentencing. There is a lying penalty that judges impose, and it probably happens in civil cases too, where people do not like liars. It's that simple. And we generally know when we're being lied to. So if a client is intent upon pursuing that course of conduct, your duty as the lawyer is to educate them, to let them know what the real world consequences likely will be if they pursue that course of action. And I think in most instances, you can talk people off the ledge. And those you can't are the people that are so boneheaded or without a conscience that they're going to take some self-destructive course and que sera is their attitude. And that's where you have the parting of the ways. The lawyer cannot be complicit in this in any way. After your best attempts to talk them out of this craziness and what would be unethical conduct if you allowed it to go forward, if they're not willing to listen to you, you are parting ways as a lawyer. Your reputation is all you have as a lawyer. What you do today can mark you for the rest of your career. And there's no client, no cause that is worth jeopardizing your stance as an ethical practitioner of law. That's your stock and trade. If people can't trust you, judges and other lawyers can't trust you, if they think you're a sharp practitioner, sharp elbows practices, somebody who gives a nod and a wink to what the truth is, and plays cute and this kind of stuff, you're toast. You just can't go anywhere near it. And I think the strong lawyer, the one who asserts their role in the beginning with the client, is going to avoid 99.9% of these things we're talking about. If you let the client row the boat, that's where you get in trouble.
And Steve, your clients are probably more interested in your representation of them than many of our insurance clients are of us representing them. I don't know how many times over the years I've heard from our clients, why am I involved? Isn't this just a matter for the insurance company?
Sure.
So having that talk with them, it might resonate more with your clients than it might with insurance defense clients.
Possibly so. I'll be very brief, but I think that whatever the subject matter is, civil or criminal, trivial criminal case, small civil case, the stakes are the same for the lawyer and should be as we explain it to our clients. Your reputation, for being a truthful person, that speaking to the client, should be critical to you. We'll find a way to get you through this legal problem you're facing, but don't lie.
I always tell my clients I can deal with the truth. I can't deal with lies.
Right.
Yeah.
Tell me anything, we can work around it. but don't
Yeah.
tell me something important and I can't make any guarantees. You know, one thing in civil cases, depending upon your area of practice, but you can get a very sophisticated client. And in some instances, a sophisticated sort of public figure type of client, not in a like movie star way, but just somebody who's well-known and well thought of in the community. And that person, you may discover that that person faced with some uncontrovertible evidence has not told the truth and continues to want to perpetuate that. And in that instance, this client who is so sophisticated and very able to mince words, be nuanced, etc., comes up with a new narrative to explain what the otherwise incontrovertible evidence is through that person's lens and wants you to buy off on that. So it's not an outright lie, black and white. It's back in the shade of gray, where you as a lawyer aren't able to judge or have an easy answer. Is this a lie? I think it probably is, but I don't have any way to prove it. And the client is saying, no, this is that document or that whatever it is. You have to look at it in the context of the explanation of how to interpret it. And I'm not lying. I'm just saying that this is really the interpretation that is the truth. And I'm trying to put this in a way that brings out in the open how dangerous this is, because you want to believe, again, you want to believe your client. This person is someone who's known in the community and thought of as a person who is forthright, truthful. But here behind the scenes, you're seeing this happen, and it's a very uncomfortable place to be. And this is what kind of Steve was talking about. Client control is really important. And if you think that your client is trying to bully you or force you to allow them to proceed down a path that you know is wrong, even though you can't prove it, you can't say to the person, well, I don't believe you because of X, or it's just a very subtle situation. What do you do then? And I will tell you from my experience, I withdrew. I just was not comfortable with it. It was a messy process. It was it was uncomfortable, and I hope I never have to do it again, because you just have to know that if your gut's telling you that this is not going to play out well, it's not going to end well, then you're wrapped in it too, and you've allowed it to go forward, even if you're kind of turning a blind eye. So this is a difficult topic. And probably everybody in the audience has had this come up at least once, but you really have to talk to the client if you figure out that you're at a dead end with your own ethical obligations. And I think you have to withdraw.
John, let me add a wrinkle to this that I know we haven't talked about yet, but it's equally important. And that is, lying can occur in a variety of ways. It can be lies of concealment, lies of alteration of documents, or deletion of things from computers or cell phones. People, have their life stories, their emails, texts, and other social media communications, electronically. A lot of people naively believe that you can actually delete those things, not understanding that forensically it can all be recovered, and the act of deletion itself is worse than what the information was. I start every case that I get by telling people the facts of life. We sit down and have a come to Jesus talk about what criminal cases are, what our attorney-client relationship is all about, that I'll fight for you like hell. I'll use all my skill, all my experience in relationships with judges and everybody else to your advantage. Your obligation is to cooperate with me entirely and to be truthful with me entirely. If you do that, we have the working ingredients of a successful relationship and maximize your chances of getting the best outcome we can get you, given the facts and the law. And you have to remind people of these things as you go along when you reach these critical moments. So there shouldn't be surprises if you do those things. And in most instances, there will not be. It's a matter of building confidence and controlling the relationship. You're the lawyer, they're the client. By definition, they don't know how to navigate the terrain they find themselves in. You know the law, you know the facts, you know the tribunal, you know your opposite number lawyer, you know how these things play out in real life. Your obligation to your client is to steer them in a safe course so they don't make impulsive, ill-considered decisions that will come back to bite them and cause these ethical nightmares to arise in the first place. I think that's the key here. And for young lawyers, it's sometimes difficult when your client is somebody that could be your parents' age or is a business person and you 4 or 5 years in practice as a lawyer. I can remember thinking, geez, I can't wait till I get gray hair. People will take me seriously. Sad fact is, when I got the gray hair, I also lost most of it. But you need to assert yourself. And if you do, you will gain respect from the client because they know you know what you're talking about, and you have certain uncompromisable principles by which you operate as a lawyer, and explain to them that that's how you get good results, by being ethical, by being trustworthy. The truth in a courtroom is a powerful, powerful event when it happens. There's nothing else like it. Lies limp across the finish line. Truth is powerful, and it's simple. You don't get complex truth. It's always a very simple narrative, and it doesn't defy the laws of gravity or human nature. It's right there. And the clients that think they can create the elaborate facade, none of them are clever enough to do that and pull it off. It always unravels, and it's worse for them when it happens.
Amber, we have just a few minutes. Talk to us about what happens when everything goes wrong in how a lawyer deals with this. You were formerly in the Office of Disciplinary Counsel. What landmines do lawyers step on that ends up putting them in the disciplinary realm?
Well, I will say that the good news for you is that most of the cases that deal with lies are the lawyer's lies to the court, not the client's lies to the court. So if you avoid lying to the court yourself, you're probably in good shape. The case law out there basically have upheld, and this kind of goes to what Martha was talking about. Lawyers are allowed to have a good faith belief in something that they either do or what their client says, and they're probably not going to be subject to discipline. There's a case out of Tennessee which found that a lawyer who did the signed signature, a conformed signature on a document based on his belief that his client's partner had signed it and submitted it. He was taken up on charges for submitting false documents or relying on a lie or perpetuating his client's lie. And the court said, no, he had a good faith belief that what he was doing was in concordant with the facts, such that that's not going to be a violation. Similarly, there's a case out of New York where a client was guilty of perpetuating his client's lie in an arbitration of all things, because the client had said that had said that she had made a payment or done something like that. And so attorney then said, yes, and I wrote a letter and told you that, instead of getting his client to fess up. In that case, that's when a violation is going to be found, because that actually is perpetuating the lie under 3.3, and that's going to be found to be violation of the conduct. But for the most part, the cases go the other way, in the sense that I was telling you earlier, where you disclose things believing that you're supposed to disclose things in order to make it right. And for the most part, even in the cases where they strictly follow the model rules and you're allowed to disclose, you have to be sure that a lie has actually been told or something's actually been done that requires disclosure, and not just a belief that your client may not be telling the truth. And so I think there's some solace there in the fact that you really gotta know it's a lie, or just be ignorant to the fact that, you have to, you can't just feign that you think that, oh, I can rely on whatever my client says. I don't think that's going to help you. But I think if you honestly believe your client's position, we're advocates. If there's a reasonable basis for it, that's our job to advocate for it.
Okay. All right.
John, let me add one final thought, and that is the necessity for lawyers to document their files. When you are dealing with a client who you reasonably believe is going to say something that is false or has said something that is false, and you are trying to talk them off the ledge and take the correct course, document your file. Bring another lawyer into the conversation with the client and you as a witness if necessary.
Okay.
Document every ethical step along the way. That will leave you, and I think, in an absolutely bulletproof position as a lawyer as it relates to the ethics.
Always good to document your file on everything, right?
Absolutely.
At this point, we're going to open it up for questions that our attendees might have. And there is one in the chat box from Kurt Peterson. Kurt, if you're still there, do you mind just turning on your mic and asking the question yourself?
Yeah, sure. Hi, John. Thanks. So I've got a current case going right now where I settled a case with a prior attorney. That plaintiff then fired prior attorney. Prior attorney withdrew, or the court allowed him to withdrew. Plaintiff got new counsel who denied that settlement had been perfected, that a contract had been formed. And I file a motion to enforce settlement, and in opposition, plaintiff files a declaration saying I never gave my attorney authority to settle this case. So my question is, what kind of responsibility does new attorney have to investigate whether or not that's true? Because either she believes her client, or she has, I guess my thought has always been, couldn't she just call up prior attorney and say what went on here, right? Or maybe she just doesn't want to know, but that seems like willful ignorance that she could investigate and find out.
So in there somewhere is a lie. And
That brings a good question to the forefront of if you two lawyers are representing or have represented the same client, can you talk to that lawyer about something like this? I always thought the answer was no, but it's an interesting question.
Kind of depends on what the client's advised. If the client's going to allow you to, but oftentimes if there's a bad break with your prior lawyer, the client's going to say, you can't talk to my new lawyer. And then that's where you are. If the client said, I don't want you, you're not my lawyer anymore and you can't talk to anybody, then that's where you are. So in terms of what he's talking about now, this is where the lawyer that withdrew may end up being a witness.
so,
in the case.
so Kurt could file a motion to enforce the settlement and call the prior attorney as a witness?
You could do it, and to the extent that there's any information they can give that's not protected by the attorney-client privilege, which is kind of questionable given the nature of it. But that's where you are. There is a duty of competence, but I don't know that you can invoke it just by saying that the lawyer could have done more to research the merits of the case. Sometimes that's successful. There's 3.1 requires you to have a basis to bring a claim, and there is some level of reasonableness in conjunction with that. But your facts are with you've told me about your facts. I'm not seeing any violations yet by that lawyer of the rules of professional conduct.
By the new lawyer?
Yes, correct.
Okay.
That's just
Sorry,
I'm not
Kurt,
speaking
I
on
don't know
behalf
if
of
we
anyone.
helped you.
Oh, thank you. I appreciate that. That makes sense.
And if anyone else has a question, feel free to turn on your mic and ask it.
Sure, I will. It touches actually on something we talked about before, and you touched on it, Amber. We talked about the noisy withdrawal in the court context, but most of us are insurance defense lawyers, and if we need to withdraw from a case because a client is lying or is preparing to lie, we need to tell something to the insurance company. Now, how careful do we have to be there? Is the concern over merely revealing client confidences, or is it a broader concern than that when we're giving our reasons to the insurance company for withdrawing?
I would think it's broader. I think that you have that obligation not to, both the 1.6 obligation not to reveal confidences, but you also have the 116 obligations not to prejudice your client's interests. And when you're in the insurance setting, you have the whole coverage issues and all kinds of other things that you have to be mindful of. And there is case law out there that has where attorneys for that in those circumstances told the insurance company too much. So there is case law out there on that. So you do need to be mindful of what your client, what's in the best interest of your client first.
Okay. All right. Thank you.
All right, any other questions? I can't see anybody on the screen, but if you have a question, feel free to open up your mic and ask it. And hearing none, I'll kick this back to Brian to close us out.
Folks, that concludes our webinar. Thank you, all of you, for joining us, but thank you particularly Martha, Steve, Amber, who took the time to present this to the membership. And really, I personally have enjoyed this a lot and learned a lot. So just a reminder to our attendees, there will be an email sent out to you following today's presentation with instructions on how to get your CLE credit. Thank you again, everybody, and enjoy the rest of your day. The sun just came out here in Wilsonville. I hope it's out where you are, and have a great weekend, everybody.
Thanks,
Thank you very
everyone.
much.
Thanks to everybody.
I'm just coming on camera to prove that I didn't leave you.
Nope, I saw you there.
I was hidden, but I thought it went well.
Yeah. Yep.
And you can tell at this point in time, the folks who took a nap are working out in the yard.
Well, I see my buddy Rod Jones there. He just sent me an IM, so I guess he's still on.
All right. Have a great weekend, Brian, and I will see you next week.
Oh, that's right. You bet. Thanks,
Yeah.
Jeff. Hey, Rod.
Hey, Brian. Hey, Jeff. Have a great weekend, guys.
Yeah.
You too.
Bye, everybody.
Bye.
He left me, so I guess I don't have to tell him.